So in Florida, for a parenting plan, it really depends. Florida courts typically require that you guys have a set schedule to determine what your overnight time sharing is going to be. And in Florida, there's now a presumption of 50-50 time sharing, meaning when you walk into a case, unless you can prove otherwise, you're probably going to get 50-50 time sharing. And that typically is 1 week on, 1 week off. It just depends on your specific circumstance and what you guys may agree to at mediation. The other key aspects is what kind of parental responsibility you're getting. The default in Florida is shared parental responsibility, meaning you come together on all major decisions for your children, like schooling, like doctor's appointments, like medical needs. That's another big key part of any parenting plan in Florida. There's also some boilerplate language that you will see, like making sure you don't disparage the other parent, don't talk negatively about the other parent. That's the basics of a parenting plan. It's very much set out by Florida courts, and essentially they're very formulaic with what they expect in a parenting plan. For a parenting plan in Florida, holidays and special occasions are usually set out by an even and odd year. Specifically, you're splitting Christmas, usually one party does get Thanksgiving. Easters are usually alternated on a year basis. And then for summertime sharing, usually it's either week on, week off, with a special provision that one party can get 2 weeks of uninterrupted time sharing. Now, with a parenting plan and with holidays, you guys can always deviate from your actual parenting plan, but the parenting plan serves as a basis for if you guys can't come to an agreement, you always have a document to come back to, especially regarding holidays. A lot of people in Florida have disagreements regarding a parenting plan, and so what I suggest to people is to try to work it out amongst themselves. And if you cannot work it out amongst yourselves for what is in the best interest of the minor children, at the end of the day, the parenting plan that you guys signed at mediation or signed in front of a judge is going to be what you have to follow. Not everybody likes it. It's not fair in many respects. It's difficult because parents want to be with their children at all times. But if you can't reach an agreement, try talking it out. And if you can't talk it out, just follow the letter of what your parenting plan says. In particular, with the situations I've seen as an attorney, I prefer a more strict parenting plan just because there's less room for disagreement. If you have a flexible parenting plan, that is great if you guys can get along with each other. You guys are co-parenting great, but a lot of times a flexible parenting plan leaves a lot of room for disagreements and arguments, and you're left wondering what exactly are you supposed to do. With a strict parenting plan, you can be flexible. You can deviate off of it if you want to, but with a strict parenting plan that has set days, you know at the end of the day you're going to get your children at minimum for those days. And so for a flexible parenting plan, I try to deviate away from those as much as possible just because it leaves more room for conflict. And because my primary focus is litigation, I have seen flexible parenting plans fail, whereas a more strict parenting plan usually survives any kind of disagreement that may occur. If you have any questions regarding creating a strong parenting plan in Florida, please contact us at cooperandcooperpa.com to discuss your specific situation, as well as for us to give you guidance on how to handle your situation.